this is Dan Smith of DPS Legal Counsel, and welcome to today's episode of Legal Scrubs, where I discuss issues of importance in the operation of medical practices and personal issues affecting physicians. And so today I want to talk about the most recent and the first of 2020 of the corrective action plans or notices put out by Health and Human Services Office for Civil Rights dealing with potential HIPAA violations. This matter involved a solo practitioner, a gastroenterologist in Utah, sole practitioner of his own medical practice, but still the Office for Civil Rights in its enforcement action went against this particular physician, and the physician just entered into a settlement agreement with the Office for Civil Rights, pursuant to which, or under which, he paid a settlement amount of $100,000 and had to enter into a corrective action plan that will involve his taking certain actions and providing detail to the Office for Civil Rights over the next couple of years. Now, what this arose from is really instructive for all you physicians out there who are just running your operations, running your medical practice. You need to take note of this matter, because this is very, very enlightening for how the Office for Civil Rights will look at what small practice, solo and small group practice physicians are doing with respect to HIPAA compliance. So this particular physician had a business dispute with a subcontractor of his electronic health records company. Essentially, the subcontractor of the electronic health records company was blocking the doctor's access to electronic protected health information of patients until the doctor paid this subcontractor $50,000. The doctor, as a result of that dispute and his inability to get access to the electronic protected health information of patients, this doctor notified the Office for Civil Rights by way of a breach notification. Essentially, there are three components to the HIPAA rule: privacy, security, and the requirement to make notifications to OCR if there's a breach in security or privacy. So this doctor notified OCR of a breach, and because of that notification, the Office for Civil Rights actually investigated the doctor's practice. After this went on for several years, because the breach notification happened in 2013, and this settlement agreement just came out about a week ago, early March of 2020. The Office for Civil Rights, in the settlement agreement, and of course in a settlement agreement, the physician is not acknowledging or agreeing to any assertion that he or his practice has done anything wrong. There's no admission of guilt or liability. It's purely a settlement with the Office for Civil Rights. But in the settlement agreement, the Office for Civil Rights alleged that the doctor failed to do a thorough risk analysis of HIPAA potential vulnerabilities at the time of the breach notification, and also failed during the pendency of the investigation. Even though he had technical assistance from OCR, he failed to do a risk analysis after the fact. He also, the allegation was, failed to implement steps and procedures to minimize or mitigate any vulnerabilities or risks under HIPAA after the breach notification, and also allowed an electronic health record company to have access, create, maintain, transmit protected health information of patients without getting an assurance from the electronic health records company that they would safeguard those records and do what needed to be done to be in compliance with HIPAA. So again, this doctor, a solo practitioner with a gastroenterologist, a small practice in Utah, gets investigated after making a breach notification because of a dispute with a subcontractor of his electronic health records company. There was no allegation in the settlement agreement that any patient records had been compromised as far as privacy is concerned. It all was because there was a blockage by the company of the doctor's access to the electronic protected health information of patients. And still, with that, the doctor was forced to pay or agreed to pay a settlement agreement of $100,000 and to enter into a corrective action plan with the Office for Civil Rights. Now, this is concerning, it should be concerning to all physicians in private practice. There are about, I would say, at least 5 takeaways, 5 lessons that all doctors who are in private practice can take from this settlement agreement. First, it is absolutely essential that doctors not minimize or underestimate their exposure under HIPAA. In fact, the director of the Office for Civil Rights, in conjunction with the settlement agreement, made an interesting statement. I'm going to read this. I have to look at my notes to read this. He said that all health providers, large and small, need to take their HIPAA obligations seriously. The failure to implement basic HIPAA requirements, such as accurate and thorough risk analysis and a risk management plan, continues to be an unacceptable and disturbing trend within the healthcare industry. This is a shot across the bow, you might say. It's putting doctors on notice that OCR and its enforcement actions that may come under HIPAA are going to be taken very, very seriously. So you cannot, my dog has just walked up to me. Do you want to see him? Just a second. Luca, go sit down. Okay. So that's number one. Physicians need to take their obligations under HIPAA very, very seriously because OCR is. Number two, you need absolutely to know who you're dealing with. When you provide access to your electronic protected health information, if your billing company, your electronic health records company, anyone with whom you contract or work with, you need to make sure that you know that you're dealing with a good company that you can work with and that's not going to cause a problem down the road, such as what happened with this particular situation where there was a business dispute and the subcontractor of the electronic health records company simply blocked the doctor's access to these records. Number three, you need to not just do cookie cutter business associate agreements with anyone you share your protected health information, your electronic protected health information of your patients. You need to look at these carefully on a case-by-case basis. You can obviously use a template, but you need to take seriously each business associate agreement you enter into. Make sure it covers what you want it to cover. And in particular, you want to make sure that it has an obligation of the business associate to safeguard and maintain the electronic health records or the protected health information. And you want to make sure that if there is any dispute between the parties, that access will not be denied to the medical practice or to the doctor because of that dispute. That's another key takeaway. The next key takeaway is that you may wish to include in your business associate agreements, or at least try to include by negotiating with your business associates, indemnification provision, so that in the event the doctor or the medical practice gets hit with costs due to an OCR investigation or a settlement, that if it's due to the improper actions of the business associate, that the business associate would indemnify or pay for those costs to the medical practice or the doctor. And finally, last takeaway, you need to make sure on a practical basis that if you have electronic health record companies that maintain or keep your electronic health records, that you have physical access to them in some other manner. There's my dog. You can see him in the picture. He's wanting to come over next to me while I'm doing this video. His name is Luca. Anyway, so that's the last requirement. Make sure that you, on a practical basis, have access to your patient record. So 1, take HIPAA carefully, seriously. Number 2, vet your business associates. 3, look at your business associate agreements on a regular basis. Don't just stick them in the drawer, and consider putting in them provisions that require the business associate to provide that information to you regardless of any dispute, and also that they will safeguard the records. 4, you want to make sure that you keep your business associate agreements up current and review them on a regular basis. Don't just treat this as a cookie cutter kind of thing. And lastly, you want to make sure that you have access to your health information of your patients, regardless of any kind of problem that you may have with a business associate. If you haven't looked at your business associate agreements in a while, you probably should. This case from Utah is a wake-up reminder for all doctors that OCR is serious about HIPAA compliance, even if it's a small one-doctor medical practice. And you need to make sure that you do risk analysis and have a risk management plan in place, and you want to make sure that you have individually tailored and good business associate agreements that you review on a regular basis. All right, that's it for today. I hope that helps. I hope you got to enjoy meeting my dog Luca while we made this video. And if you have any questions, please feel free to reach out to me, and we'll see you next time on Legal Scrubs.